Hi, everybody. Welcome to Trial Alchemy, and it's great to have you here today. My guest is Chris Wesierski, and Chris is an outstanding ABOTA member who is a lawyer who handles mostly defensive cases. He's been practicing law for over 40 years, and his work is in the area of insurance defense, employment matters. He's the founder and the managing partner of Wesierski Zurek up in Orange County, with the specialized practice involving business, tort, and employment litigation. He lectures frequently and helps educate other lawyers on standard of care issues, and has participated as a speaker and moderator in a number of industry conventions and conferences across the US. And he's been hired as an expert for trial. Chris went to USD a couple years ahead of me. I guess I was the first year when you were a third year, Chris. He's tried over 100 cases to verdict, and he's a diplomat in the American Board of Trial Advocates, over 100 trials to verdict. Chris has too many accolades for me to list all of them. I'll list just a few today. He was the ABOTA Trial Lawyer of the Year in 2018. ABOTA has about 6 or 7 chapters in California, and once a year, all the chapters collectively pick somebody to be the Trial Lawyer of the Year. So that's a great honor that Chris received back in 2018. He's been listed by the Daily Journal as having some of the top 20 defense verdicts in the past. He's been listed by the Daily Journal as being one of the top 75 employment lawyers in California in the past. He was named as the Trial Lawyer of the Year by the Orange County ABOTA chapter, and he's won many, many other honors during his distinguished career. So, Chris, thank you very much for joining me today, and welcome to Trial Alchemy.
Thank you so much for having me, Monty.
Well, Chris, let's start off with this, and that is you've tried a lot of cases, and in your vast experience of trying cases, what are some of the most satisfying trial victories that you've had?
Well, interestingly, we just finished my first plaintiff's trial where we asked the jury for punitive damages because the jury found malice, oppression, and fraud in a plaintiff case. And I can't brag about this because it was my partner. I left to go watch my grandson play volleyball in Florida. She tried it, the second phase, and she asked the jury for $3 million, and they gave her $4 million.
Well,
So that,
congratulations. That's
thank you.
awesome.
Yeah, in the first phase, we had 13 causes of action, and they found liability on all of them. But that's my one and only one-off, if you would, plaintiff's verdict. In the past, I've had cases that people just thought there was no way we could win. For example, we make an offer above the policy limits in an auto case. This was in Santa Monica. We had an offer for, I think it was $600,000. They refused it. Had to have 4 or 5 million, lots of injuries. Plaintiff had cervical disc problems, laminectomy, both there and also in the back at L3-4, L4-5, C3-4. Our lady had blown a stop sign and T-boned somebody, and they found while we were liable for the accident, we were not liable for the injuries and no causation. So defense verdict 12-0 on that. The other one that I'm kind of particularly proud of, a renowned plaintiff's lawyer, very renowned. Now he's had some big verdicts even since. In Lancaster, a lot of cases that he tries. This one happened to be in Chatsworth. We actually had a driver who was driving along, hit something in the road, claimed it was a deer, but it was a person, and he killed the person, unfortunately. Drove home, washed blood off his car. The whole right side of his car was destroyed. Came back to the scene, was found to have marijuana and alcohol in his system. They filed a suit for wrongful death and defense verdict in that case. The judge actually said to me, Mr. Wesierski, I presume you're going to admit liability. And I said, I have something to talk about here, I think, Judge. And the other attorney said, well, if I can't win this case, I probably should retire. So yeah, that was a surprising verdict. So I've had a few where people said, you can't win and you're sort of stuck having to try them, and then you end up winning. Of course, I've had some that I thought I could win that I lost. And anybody who says they never lose either hasn't tried enough cases or isn't really telling you the truth.
Yeah, if you really try cases, you're going to lose once in a while.
Absolutely.
But it sounds like you've had quite the record in dealing with cases with significant injuries, big dollars at stake, and yet you've been able to bring in these kinds of defense verdicts.
Well,
Do you attribute that? What do you attribute that to?
so we have 40 lawyers now, Monty, if you can believe that. I never thought I'd be that big, and that's small, as you know, in the big scheme of things. But I think preparation, I have a great team behind me on every case, different groups, but they all know how to try cases. I have great paralegals that know how to try cases, and they use IT very well. So we have interesting opening, closing arguments with good PowerPoints, and just preparation, preparation, preparation. That's the key, knowing the file better than the other side, and hoping that you can get your points across. And then, I've learned through the years, sometimes less is more. So you don't want to go after the high hanging fruit. You want to just go after the low hanging fruit, the obvious points. Make those, make just a few of them, make those your themes and get out.
I think that's great advice. I think less is always more. And if you can distill it down and make it as simple as possible and as easy to understand as possible, no matter which side you're on, you're going to give yourself the best chance to win.
Absolutely.
Yeah, and that's what you are doing. That's what you've been doing. Well, that's great. And preparation is a key, isn't it? Because you really have to know that case. You can't come in and try to be learning the case during the trial. But um, in terms of your preparation, do you have a system and do you have a process? Because you have these teams helping you, but how do you do your final prep so you're ready and you've got everything ready to go?
So I normally don't handle a lot of cases come into us at the last minute. Hey, we can't settle this. Will you try this? So
Hmm.
I may not do any of the depositions, even if the case is in early. Um, I will have others perhaps work it up. But towards the end, when we get close to trial, I read every single deposition very carefully. I read all the documents in the file very carefully. I pull out what I think we need for exhibits, try to keep it to fewer than more exhibits, try to limit the experts, and make sure the experts and the witnesses are well prepared so that they've read what they need to read, make sure that they know the themes, make sure they understand what happens in a courtroom if they're lay people, um, and just make sure that you go over in your mind, what am I going to say to this jury? What are my main themes? How do I get those themes across? And what's the reason that we should win this case, or at least hold the damages down compared to what they want to ask for in the case.
Yeah, so in your cases, when you're typically on the defense, you're going to have a victory if you have a defense verdict, but you may also have a victory if you keep the damages lower than the plaintiff's been asking for, right?
Well, the defense attorneys always like to say there's a lot of ways to have victories. One, you could outright get a defense verdict. That's your best one.
Yeah.
Two, you could beat your offer. That's also good. Three, you could beat a 998 and get costs back. That's also good. Or four, the verdict is closer to your offer than their demand. So there's at least four ways, probably five ways that you could achieve what we call a victory in the end. And five would be where you don't have a choice and you have to try it, and you try it and you hold the damages down and you don't end up spending a whole ton of money because you were able to succinctly narrow the issues down and narrow the facts down.
Now, in terms of trying to with and have the right theme for the case, you mentioned that earlier. What are some of the themes that you've used that have been really successful for you in defending these cases?
I think in auto cases where I started, the fact if you like the client, hopefully the jury will like the client. The fact that they tried their best, but they, for example, medical emergency where we've won cases where somebody got stung by a bee, and that was a defense verdict, or took some medication that made them go unconscious. That was a defense verdict, and that's because they liked the defendant, were able to side with the defendant. So try to see what a jury might see, from your standpoint, from the defense standpoint, and then try to present it as reasonable. I had a case actually in your neck of the woods, San Diego, against a famous San Diego trial lawyer, where a young girl was crossing the street, and unfortunately our client hit her and caused severe brain damage. But he had the sun in his eyes, and it was very severe. And we
Hmm.
had a belt recording from one of the officers that was at the scene, and then we had a recon go out, a reconstruction expert go out at the same time, same day, like a year later, and also tape it. And you could see the sun was just blinding. And we got a defense verdict in that case because of the sun being an intervening factor, even though people thought, you know, how are you going to win that case?
Now, when you have a good defense client, that makes it easier because anybody on either side, if their client is a good, likable client, it helps your case. But
Absolutely.
you don't always get to choose your clients. So when you've got a client on the defense who's not as likable, um, do you take a different approach with themes and trying to get the same result and get a good defense verdict or a good defense result?
Yeah, I try to make the jury identify with me rather than my defendant, who may not be likable. And also, if I have a good expert, hopefully they can identify with that. I usually try to pick one expert that's really, really good. Maybe it's a radiologist. Um, Maybe it's somebody who just is tough to cross-examine. Stephen Rothman, who's passed away now, was a good neuroradiologist, and people used to ask him, on cross, you make a lot of money. He would volunteer on direct. I make a lot of money because I do this a lot, and I'm good at it, and he was hard to cross-examine because he was very knowledgeable. So you maybe have him identify with that one expert who can win the case for you when your client isn't so good, and you want your client to take a very low key stance in the courtroom, maybe be there but don't nod, don't do anything, don't make call any attention to yourself. um, just try to kind of sink into the chair a little bit. But I've had witnesses and clients that were terrible. I had here's a funny true story, unbelievable. Judge sent me a case. Her, um, it was her. Let's see, yeah, her veterinarian, nice guy, had been sued for sexual harassment, and it was a partnership dispute. And during the trial, he was behind me, so I couldn't see him. He was at the rail, and he was nodding and shaking his head. And I get called in the back by a friend of mine who's the judge, along with the plaintiff attorney, and he says, "I just want you to know your client is making all kinds of faces. He's doing all sorts of stuff." So I take him in the stairwell and I say, "Can I have a minute with him?" Sure. Take him in the stairwell and I give him the famous line from a movie: "Help me help you, because you're killing me right now." And I said, "I don't normally lose, and you're going to cause me to lose by doing that." "Oh, I won't do it anymore." So honest to God, this is true. He then fell asleep and snored in the courtroom during trial. And it was like, very, very loud, which was at least better than him shaking his head vehemently. And we got a defense verdict. It was a very bad case with a tough plaintiff who turned out she lied. And the I'll never forget this. The expert during that trial said to me, and this is something a lot of young attorneys don't know: you can go up to the expert and ask to see their file. So at a break, I asked to see his file, and for some reason, the other side left the courtroom.
Oh,
So he says to me, "Ask me the right questions, I'll give you the right answers." Because
wow.
he did not like the plaintiff, and he was a psychiatrist, and actually turned out he hated her. So he just volunteered after that all kinds of bad stuff against the plaintiff, unbeknownst to them. Although it was in his report, you could read between the lines and see where he was going. Um, but yeah, so I'll never forget that the same case. They accused him of making a sex call to the plaintiff, the veterinarian, and he was sort of a chubby guy, and he had corduroys on, and he had unfortunately butt dialed her. I called it the butt dial defense in trial, and you could hear the corduroys making a noise as he walked, but they thought it was him calling her while he was having sex with somebody else,
Oh
and
my
made a
goodness.
made a big thing about it. That was pretty interesting. Fun case, very fun.
Well, that example with that expert, you prepare and prepare and prepare in your trials, but sometimes things happen that you don't know is going to happen.
All the time.
I mean,
All the time.
what a gift that was for you to ask to see the file, and he tells you that when
Yeah.
you're out of the room.
Yeah. I've had so many things happen to me. I had a case defending a big hotel chain where I wanted to show the lights were lighting up this stage. This lady fell off and they wouldn't work in trial. And we couldn't get them to. I mean, I don't know what was going on. The lights were defective that we brought in or something. So you just got to roll. I mean, I've had cases. Uh, I remember in Riverside, they were so jammed up, they were trying cases in a schoolhouse. And that
I
was
remember that. Yeah.
yeah. And they'd shut down the schoolhouse. It was a grade school because the train would go by every 40 minutes and you'd have to stop talking. Well, I tried two cases there. One of them, I had two jurors that had been room moms in the room where we tried this trial. It was in like a regular little grade school room. And the funniest thing of all, Monty, was seeing these experts at very expensive rates sitting on these little benches for grade school kids out there with their legs up in the air, trying to get a drink out of the drinking fountain that was down low. And that was another fun trial in Riverside at the old schoolhouse. That was really fun, interesting.
Oh my goodness. That was back when they were trying all the criminal trials and you couldn't get out to civil cases, right?
That's right. The DA refused to plea bargain, and so you couldn't get any civil cases out. So what they did is they brought in retired judges. This happened to be a guy named Burby, Brill Hunt Burby and Dubois. This was Bill Burby, was the trial judge, retired, came back, and he's in this courtroom in a makeshift kind of desk for himself. The witnesses would come out in the middle in a rolly chair, and the jurors were all situated in there. It was very tight and confined, and but you got to just learn. What I learned is whatever the situation is, whatever your courtroom is, if the judge is coming down on you, you got to just roll with it, do the best you can, and keep going. You can't let anything get you down. You got to not show it. If you had a terrible day where you wish the ground would open up and swallow your chair and you together, you can't show it. You can't act like it. You got to think. I tried a lot of cases next door to Johnny Cochran, and Cochran always looked like he was winning every trial, even when he was getting killed. He literally was smiling after they killed him with witnesses, and I talked to him about it, and he said, "Yeah, that's the way I project." He got to where at the end he was being handed scripts, and he would just go off cross, not even prepping, and read the cross they had prepped for him.
Oh my
Uh,
goodness.
yeah, but I learned that from him, never to show weakness or show that you were just killed by some witness.
Well, I've always called that you got to keep your poker face. So as a
Absolutely.
trial lawyer, that jury is looking at you and they're looking at everybody. And so even if they're killing you on their cross-examination of your expert or your witness or whatever, you got to look like you're having a great day. Nothing's going wrong. It's all great. But you got to, like you had with that client, you got to tell your client, you got to keep that poker face.
Oh yeah,
You can't
yeah.
show emotion. You can't be making gestures or shaking your head yes or no. You can't do that.
Yeah, no, absolutely. And thank goodness the judge called it to my attention because I couldn't see him. And he went ahead and fell asleep and snored. I'm not sure. And he was the nicest guy in the world. He was a very nice client when all was said and done. But boy, yeah, he was. I'll never forget going in the stairwell saying, "Help me, help you." I'll never forget another stairwell talk where I had three experts. One guy comes in. He was a neurosurgeon, and he had had an issue I didn't know about with an addiction problem. So he was absolutely not ready to testify. Another guy comes in and I'm asking him questions on direct, and it was sort of apparent to me he didn't know the file. So we go in the stairwell, and he said, "Yeah, I was busy yesterday on another trial. I didn't have time to reread this." And I said, "You're killing me up there. We're going to ask you these questions. And this is what you said in your report. Here, look at the report." And I asked him like 6, 7 questions, got out. And then the third witness was Stephen Rothman. And he saved my bacon because he was so good. I ended up winning without the other two, the neurosurgeon and the accident recon biomechanic. Thank goodness.
Thank God you had that really good one.
Yeah.
So before we get into trying cases a little more, let me ask you another question. You've been a longtime member of ABOTA. I have
Yes.
too. But why is ABOTA important to you?
A lot of reasons. American Board of Trial Advocates is the largest trial organization in the country. I'm a member of 6 different trial organizations. I'm currently president of International Society of Barristers, which is also a favorite organization of mine. But for example, they have 620 lawyers. ABOTA has close to 8,000. So far more contacts are available in ABOTA. ABOTA is nationwide. So if you need a lawyer in South Carolina, you can call somebody in the ABOTA book. You know they're going to be pretty good. And not only that, I'm teaching at the ABOTA Trial College next month for a week to young lawyers, all about trial techniques and trial advocacy. So ABOTA fosters jury trial appreciation. They have all sorts of programs besides jury trial appreciation. They have civics that they now do for the younger people. They have a number of various things that you can join. Constitutional Day here in Orange County, we have a park that celebrates the Menendez case, and we have ABOTA people that go out with the public and they present on Menendez and what the Menendez case is. And real quick for your viewers, Menendez is a precursor to Brown versus Board of Education, where a Hispanic family was denied access to a white school, yet their cousins, the Vidaris, who looked white, were granted access to the white school even though they were Hispanic. The Hispanic family sued the school districts saying, we have a school with dirt floors and terrible books and no facilities, and we should be allowed to go to the white school. And at the time, Monty, Hispanics were not allowed to swim in the pool except on one day when they would clean it the next day. They weren't allowed to sit in a movie theater down below. They had to sit in the loft. They weren't allowed to buy in certain areas. It flat out said on there, I think it was Mexicans not allowed to purchase these homes. So during that time frame is when these people sued. And interestingly, one more quick step, the people that sued were renting a house from a Japanese family that had been dislocated and shipped off to a Japanese internment camp. So that's
World War II.
Exactly, Korematsu. So that's a whole nother lawsuit. But they sued and they won. Earl Warren was one of the participants in that. And I think from that, he then built on that to be Brown versus Board of Education. But the Menendez case is a famous case because of that.
Well, that's great. And thanks for telling folks about what ABOTA does. And ABOTA helps protect our right to a jury trial under the 7th Amendment, right?
Absolutely. That's the primary focus for ABOTA, and to keep the jury trial alive. There was a big, ABOTA was founded by 7 or 8 different people, plaintiff and defense lawyers. And it was founded because at the time there was a big movement to have no fault and let's get rid of these jury trials. We don't need them. And strip away the right to justice for both plaintiffs and defendants.
Yeah.
So the ABOTA members, who were also at that time members of the American College of Trial Lawyers, ACTL, which is the oldest of the trial organizations, started ABOTA in order to really foster the right to jury trial and push that.
Well, that's great. So now we've talked a little bit about your preparation for trial, and you've tried over 100 cases, and everybody has their own different opinions. But I want to ask you now, in your opinion, what is the most important part of the jury trial and why?
You know, it's interesting. I kind of change year to year on that. I think let me give you an example. Mini openings first came out, and the plaintiff bar really wanted to do them. I was against it. I'm really now a big proponent of mini openings. It's mandatory under the code because it used to be the judge would read a kind of a sterile statement of the case. Mini openings now are your chance to give a 3 to 5 minute brief synopsis of what your case is about, elevator pitch.
Yep.
And I like the mini openings a lot. I think that's really important. I also like, I'm going to pick 3 areas. Voir dire. I think voir dire is very important to kind of figure out if a juror or more than one juror is biased against you, possibly, and why. And then I think closing argument. I know opening sets the stage, but closing the argument really drives it home. So for me, mini opening, voir dire, and closing argument.
Okay.
I also, the other thing that the thing, if you were to ask me what I love the most, is cross-examination, because cross-examination is,
The
you
most
know,
fun.
the most fun. You either got it or you don't. And if you're prepped and you
Yeah,
can think on your feet, cross-exam is the most fun ever being a trial lawyer. That's just great.
it's tons of fun.
Yeah.
It's totally tons of fun, but you got to be ready. You got to be prepared. Well, let me ask you about a couple of these things. So, like in the mini opening, I've heard some of our ABOTA plaintiffs guests talk about, well, I'll use that brief time to talk about some of the bad points in my case to get some information as we're picking the jury. What are you using the mini opening to do?
Yeah, I've heard that too. I don't do that. I just give them the main themes. Here's my main themes. This is where we're coming from. Here's why we believe we're not at fault because of this, this, or that. Try not to argue it, of course, since it's a mini opening, but mainly
Right.
just give them the main themes that are going to be coming up so that in voir dire, when you're asking the questions, they can see why you're asking those questions. And they can read between the lines as to why you're asking that. So and I've heard people say I like to get out all the bad stuff, up front. Sometimes what happens with that, you get a jury that runs away with that. Somebody
Yep.
says something bad for you, and now
Yep.
the whole panel, is yeah, I believe that. Like on the defense side, you're never so happy as when somebody says, "I'm tired of all these huge verdicts. I'm sick and tired of it. I don't care what you ask for. I'm not
Yeah.
going to give it." And then he's excused or she's excused, and the next guy, "Yeah, I'm tired of it too. I'm not giving those." I mean, I've had voir dires where I remember in the one where I got a defense verdict, one of the jurors, prospective jurors said, "Well, I was just across the street, and you said a mini open, your client's real hurt and this and that. I was just across the street at Starbucks with your client. He didn't look hurt at all to me. In fact, he was chatting away and happy as could be." And so you just don't know. I remember I had a case in Santa Barbara, three Hispanic females that worked at a dentist's office, three Roman Catholics, uh, two who were pregnant. My dentist fired all three, and I thought, oh, this is a tough case. When you read the facts, got a defense verdict for all three. Two of them were easy because one didn't sterilize her instruments, and you got to do that. The other one was just very incompetent. We had witnesses to testify that she was a terrible chairside assistant. But the third one was the manager, and I couldn't find a witness to tell me that she was a bad manager and she was mean, and nobody would say that. So in voir dire, the judge always asked, "Does anybody know anybody here?" And one man raises his hand. "I know Miss, Miss Blanca Blank over there. She was the manager at my dentist's office." And he smiles, and so the plaintiff attorney's thinking, "Oh, this is going to be good." So the judge turns it over to plaintiff counsel. "Okay, go ahead. So how do you know my client? What do you know about her?" You smiled when you said her name. He said, "I smiled because she was the worst office manager I've ever seen in my life. She was so terrible. She was so mean to the clientele." It went on and on. So he tainted the whole jury panel. So that, and then I was able to cross-examine her and get her on some stuff. But while technically he was not a witness, the fact that he had pointed that out and most of those jurors still sat for trial was a good thing. So you can get a runaway voir dire if you're not careful about, trying to get the bad stuff out first.
Yeah, and that could be a problem. But I agree with you about the benefit of the mini opening because you remember that statement we used to give, it was so bland, it was so boiled down, it was so worthless that that's the only thing everybody would agree to. It's like they didn't help at all.
Exactly. In fact, it would be, this is a case about a breach of contract. And both sides would fight about what do you put in the statement of the case to make it
Yeah.
so bland, it was meaningless. So now with these mini openings, you can at least get across to the jury, what is this case really about? Why are we
Yep.
here? Yeah.
Yep.
So I'm a big proponent now of mini openings.
Well, that's great. And you, like some other defense lawyers I've talked to on this podcast, you didn't like it at first, but you become a fan.
Yes, exactly.
Yeah. Well, that's great. Let's talk about voir dire in a second here, because we talked a little bit about opening statement, but have you tried cases since we've come out of the COVID pandemic?
Oh yeah, I just finished one last week.
Yeah.
A week and a half ago. Sure.
Yeah, and that was your plaintiff's trial, wasn't it? Or is it
Right.
another?
And I had couple defense cases before that. There were bad faith defense cases.
So in your experience, I mean, some people that I've talked to who are the plaintiffs' lawyers generally, but even some defense lawyers have said, well, we think the juries may be acting differently. Do you think there's much difference, or is there a significant difference in the way juries are acting after COVID?
I've heard, and talked to some people that said the jurors can give much higher verdicts now since COVID. Um, I think because, well, that case we just finished, I couldn't say that my plaintiff had COVID because he was diagnosed with the flu right at the beginning of 2019 before they knew it was COVID, but he lost sense of taste, sense of smell, and then he got fired.
Mm,
So I think the jury reacted and gave so much money in the punitive damages because it was COVID. They've now seen a lot of these situations, and they've seen where people are being discriminated against because they have COVID. So in that case, it directly affected, I'm convinced, the punitive damages. Plus, my partner is very likable, very nice. But yeah, I have heard that the verdicts can be higher. We certainly are seeing from the defense side what they call nuclear verdicts more frequently now, where you get these huge
right.
awards that are just astronomical, $100+ million. You would never have seen that 25, 30 years ago. And I don't know if COVID has something to do with it. I think people working at home, not in the office, more individualized, perhaps, maybe maybe more willing to give a little bit higher number than they used to give. But I've tried a couple cases since COVID and been okay, been defense verdicts for bad faith cases.
Yeah.
So yeah.
Yeah, I think it's gonna vary case to case. So let's talk about this before we get into the voir dire. There are a lot of lawyers who will use focus groups and other tools to get ready to do their voir dire and ready to present their case. And some people use it all the time. Some people use it sometimes. Do you use focus groups? And if you do, how do you use them?
I normally do not. I have, of course, in the past many times used, um, trial jurors, people that are coming that are called in on huge cases, and I've used jury consultants that I think can be very good. But
Yep.
normally, I do not use jury consultants. Normally, I do not use focus groups. I just roll without it, and I think because I have over 40 years now, I have a pretty good background. I could be wrong, of course, but a lot more understanding than I had 30 years ago, of course, on how it works and what jurors might think. And depending on where we're venued, San Diego, I had my quickest verdict ever was 6 minutes on a Taco Bell case years and
Wow.
years ago. Slip and fall where somebody lied, just flat out blatantly lied, um, caught her lying. So San Diego is a favorite jurisdiction for me because of the law school. Went to school down there,
Yeah,
and it's conservative. Most of the time it's pretty
it
conservative.
is.
Vista is conservative. Orange County can be fairly conservative.
Yep.
Chatsworth here in LA can be conservative. Then you get some anomalies in LA. Downtown you don't know what you're going to hit.
Yep.
But honestly, I had a defense verdict on a bad faith case after COVID in 40 minutes, and it was all different ages, all different backgrounds, from a janitor to I think a CFO, in a tight courtroom downtown LA. I really am a big believer in the jury system. I want to tell you, I really truly believe our system's the best in the world. I mean, in the International Society of Barristers, we have people from all around the world. Um, and the Canadian system, they don't have juries; they just do judges. And I think I just really believe in the jury system. I think that 12 people are going to get it right. The other thing I will tell you that's interesting
And
in
I agree with you on that.
yeah, in England, there are lawyers who are barristers, and then there are what we now call KCs, King's Counsel. It used to be QCs. Those are the elite of the elite. They try any kind of case. You get a criminal defense case in, they try it. You get a criminal prosecution case in, they try it. Civil case in, they try it. If you can try a case that's defense, you can try a plaintiff's case. If you can try a civil case,
Right.
you can try a criminal case. All you got to
Right.
know is what is the law and how do I get it to a jury. So the advantage for us is that. The other advantage, Monty, and I don't know if this has come up for you in prior podcasts. One great thing about being a trial lawyer, one really great thing these young lawyers need to know and think about, AI is coming. It's coming in the future. It's here now. They can't replace a trial lawyer with AI. You got to have somebody up there. You could ask AI to write you a closing argument. You could
Yep.
ask AI for a cross exam, but you got to have a live body in there doing the courtroom. And AI will never replace a trial lawyer, thank goodness. So
Boy,
that's a
that's
job
true.
security. Yeah, that's
Well,
job security.
I agree with you about the jury system working and working great. And I've actually had I think, wonderful experience of having served on two juries in San Diego. They were criminal cases. And in both situations, my experience was they were really trying to do their job seriously. But my other thing that I learned was they don't analyze a case like we lawyers and judges do. And they analyze it in a very different common sense way, but I think they get to the right answer. So I'm guessing part of what you do in trying to communicate with the jury, and maybe why you don't need jury consultants, if you can talk to people on the jury about common sense issues and morals and values, I think that's what they really use to figure out their decision.
Absolutely. I think, I think juries, when they get together, there's 12 different bodies. That's 24 different eyes, 24 different ears watching, listening. I've had juries. I had one jury who actually came back in about 2 hours, and they took apart all of the jury instructions, cut them apart, and repasted them together in what they thought was a better order. And darn if it wasn't pretty good. I mean, it was pretty, and they did all that in 2 hours and came up with a verdict. So I have never had the pleasure of serving on a juror myself, but I've had judges, I've had lawyers, lots of lawyers on juries. I've had teachers, you get a lot. Retired people, you get a lot. And I'm proud to say I got a defense verdict on a case against UCI where there were three people that barely spoke English from all different countries. And I
Well,
thought, this is great. Here they are, and they wanted to be on the jury, and they would raise their hand if they didn't understand something. But I really believe the system works. Once in a while, you have an anomaly where something comes up and you don't understand the verdict and how could that be. But most of the time, I think they get it right. I really do.
I agree. I think they really do. Nothing's perfect, but I think most of the time they get it right.
Yeah.
So in your voir dire, when you're trying to pick your jury, what kinds of things are you looking for in your potential jurors, and what kinds of things are you trying to do in terms of trying to see if they're a good fit for this case?
So I'm trying to make sure I don't have anybody on the jury that absolutely hates our side. So, I will always ask, is there anything about what you've heard that makes you think that you just couldn't vote for my side, or some words to that effect? And sometimes juries will say, yeah, I've had juries. I had a case in Long Beach where two jurors raised their hand and said, I haven't heard one thing from your client, but just looking at him, I don't like him. And I said,
Oh,
well, you haven't heard a thing that he's got to say yet. And they said, yeah, I don't care. I don't like him. So you never know, but I try to look for anybody who's obviously biased against us
yeah.
or obviously biased for the plaintiff. Maybe their father or their mother or their brother or they had a similar accident or similar injuries, and they can't separate that situation. I look for anybody who's got a real emotional tie to one side or the other, so much so that maybe they can't be fair to my side or the other side.
Yep.
Um, especially that comes up with sexual harassment um,
Oh, yeah.
cases. And I try to get out of the jury. How do they generally feel about the situation they're in here? I mean, are they so mad that they can't even think straight because they don't want to be in the jury room? They don't want to be sitting there for 6 or 7 or 10 days, whatever it is. Um, but generally speaking, I'm trying to make sure that nobody is going in the back there that's super biased against the defense or the plaintiff. I want somebody who's just going to be open-minded and listen and be fair. I usually, too, on the defense side, want somebody who's fairly intelligent that can follow what we're saying. and
Yep.
we'll follow the law. If somebody says, I don't care what the judge tells me, I'm going to make up my own law, you don't want them. It's probably excused for a cause. You can tell the ones that are trying to get out of it, making excuses. I had a
Right.
judge now who's passed away, Judge Chavez in LA, where a guy, said, I just can't be fair, to the defense. And you could tell he was kind of making it up. And Judge Chavez called him to the sidebar and said, I think you're lying. I think you're making it up. I'm going to excuse you, but shame on you. I mean, he just chastised him
Ah,
for, really saying he couldn't be fair, even though he could. So I'm looking for somebody who could be fair to both sides, really. And I'm
yep.
looking for somebody who's open-minded. And I'm looking for somebody who's fairly intelligent. I don't want somebody who can't follow what both sides are trying to present.
And are you also looking for people that you think are going to be leaders on the jury?
Not necessarily. I mean, I don't try to plant or pick a jury presiding juror or a foreperson.
Okay.
Um, because those people, for me at least, Monty, are a wild card. Somebody who has a strong personality, if they're going with you, that's great. But if they're not going with you, that may be really
That's
bad.
right.
So I don't necessarily want all sheep, but I don't want somebody who's a real, I'm voting for this candidate no matter what, that kind of person. No, I don't usually want them.
One last thing on voir dire, you've probably been seeing this now, but as we all age and we're getting younger generations serving as jurors, are you seeing any things that you think are noticeable about millennial jurors or people like that who are starting to come into the trials?
I think about that at my age. I think in a way it kind of helps me because I think they know that I have a lot of background behind me doing trials. Just because of my age, they presume that. But I think millennials who are used to looking at their phones and used to looking at their laptops and iPads, you've got to use PowerPoints, you've got to use visuals more
Yep.
so than ever. I mean, when I started, Monty, it was flip charts, giant
Yep.
flip charts, and you would handwrite. And I had the worst writing ever. I
Yep.
remember with my grandson, who's now 16, writing in the hospital room my closing for the next day when he was being bored, and you could barely read it the next day, and then flip charting through it. And I didn't even used to use flip charts. I used to just talk. My partner Zurek does that. He just talks. He's great at it. He can tell you a story and you can see the story. He pre-paints it so well. I'm not as good, so I need to use some cues and I need to use some PowerPoints. But yeah, especially with millennials who are used to visuals, you've got to use visuals and oral.
Yeah. So now when you're giving your opening statement, I'm sure you're using visuals, things like that. Do you try to use things like depo clips if the judge will let you do it as part of your opening? What's your strategy in the opening and telling your story and getting your story across?
Yeah, generally not depot clips, but exhibits. I tend to use exhibits, key documents that I'm gonna make sure they see again and again, maybe 4 or 5, and also themes. I'll use pictures as themes. So puzzles, uh, pieces hooking together, or building blocks. Building. This will end up here,
Yep.
or scales of justice, um, or But I try to use visuals that I think they can associate with our themes.
Okay. And in terms of once you've given that opening statement and you're now in your direct and cross, let's start talking about that a little bit. We'll talk about cross in a second, but direct's important too because you've got to get your witnesses tell their story. So, what's your approach to cross? I mean, direct, and how important do you think that is in the case?
I think very important. So what happens on the defense side a lot is they'll call your witnesses. The plaintiff's attorney will call your defense witnesses.
Under 776?
776 of the evidence code. I think it's very important that you get right up and do your full direct right then and respond to what they did on their 776 cross exam. Because if you sit on it, if you're not ready, they may forget and kind of just remember the 776 part. And I think you got to prep your witnesses to say, look, if they call you first, I'm going to go through all this with you and whatever they cover on 776 that I haven't covered. But I think you need to go through the facts. You got to go through their background. You got
Yep.
to go through important things that they have to testify to. I mean, you want to make a list of what do I need to get in front of the jury? What exhibits do I need in through this witness?
Right.
And how am I going to get them in? And are they hearsay? Are they going to object on hearsay? Are they going to object on other grounds? How do I
Yep.
respond to that? Trial is a lot like a chess game. If they say this, I'll say this, then they'll say this in response, and I'll say that in response. And even when it's real important, you might have pocket briefs for direct
Yep.
exam. So I need to get into this area and a pocket brief, 3 pages to tell the judge, hey, look, we can do this now. And here's a pocket brief showing that we can, because there's this objection on hearsay or an objection on, depending on the case on background or outside of their expertise or whatever. And you might have a pocket brief ready if it's real important to you, or
I
just
think,
in your head, think about it.
yeah, pocket briefs I think are very powerful because I think a lot of lawyers make a mistake of trying to raise everything emotional limine. But if you've got an evidentiary issue you anticipate and you don't know if it's going to come up or if the other side's thought of it, you have that two-page, 3-page brief. You've just thought about it. That makes a hell of an impression on your trial judge. It
Yeah.
really helps you.
Plus, it helps you on the record for appeal. If you
Yeah.
need to appeal and he denies it or she denies your motion, or you've got the pocket brief right then, you can say, I gave the judge a pocket brief and they ruled the wrong way. So I think pocket briefs are key. But direct exam, I had one of the highest compliments. I tried a case to a judge who was the son of another judge who was a federal judge. He was an LA judge. And he told me with the plaintiff's attorney in the back after the trial that it was the best direct exam he'd ever seen. And I didn't think that way. And he said, the reason it was so great, Chris, is that you just sounded like you were having coffee with this expert, sitting down, talking about general, keeping it simple and just having coffee. And you guys were just chatting. It wasn't like you were even asking him questions. It was weird. He said,
Yeah.
it was so powerful the way you did it. And I'd like to say I planned all that. And it was, but I didn't. But he thought I had, which was a nice thought. But so I think direct exam is very important for not just your lay witnesses, especially though for your experts. Really important.
Yeah, I think direct, you got to keep it conversational like you did in that case. But also, and this is true on both direct and cross, you got to listen because there may be something that your client or witness says that you don't have in your outline, but you want to follow up on, right?
Right, right. That you didn't even know about. And then,
Yep.
I would have loved the days when just you and I were right at the back end of this where there wasn't any discovery hardly. You just
Right.
found you had a thin file about this big and you just tried it off the top of your head. You did cross exam with whatever came up in trial and whatever you could think of, and you didn't have much documentation to go on. Now you got the internet, you can search for everything, and you got a lot more prep that you can do. But I think for cross exam and direct exam, the more you can think about what are they going to do and what am I going to do in response? How do you act as if it's a chess game? What do I do to make sure my chess pieces go into the right spot?
You got to always figure out how you get your evidence in. It's definitely a battle. It's a chess match. You got to anticipate and you got to be ready.
Yeah. Yeah.
So let me go back to the 776 because I think you're kind of suggesting something that I ended up discovering. I've tried both defense and plaintiffs cases, but probably over the course of my career, more plaintiffs. And I think I did more 776 earlier in doing trials with plaintiffs, but I stopped using it as much because it seemed to me I could make good points on cross, and then the defense lawyer tells their story, and if it's early in the case, it's like I'm not even getting my points across. So
Right. I think exactly good point. I think plaintiff attorneys might make a mistake if they, for a while, that was the way they were taught was to put everybody on 776 if they're
yep,
key
it
witnesses.
was.
But if the defense person is ready for that, and then they get the whole story out before you even have your plaintiff on the stand, I'm not sure that's the best way to go.
I think that hurts the plaintiff's case, and it can help the defense case. So it can backfire on the plaintiff. They got to be very careful thinking about that. So let's talk a little bit about cross. Now, when you're crossing your witnesses, I like to think about cross, and there may be more ways than this, but you've got the traditional cross everybody's taught in law school. You and I were probably taught the same thing at USD of, control the witness, close questions, just trying to get a yes answer, and you're not giving them any wiggle room. But then there's the different, crazy different kind of a cross I've seen with Jerry Spence and other people where I'd call it an open cross, and they're not trying to control the witness. They're more telling their story. Do you tend to use one type, or do you use both types in different situations?
I use both types, and we were taught. You were probably taught Irving Younger's 10 rules of cross exam. Never
Yep.
ask a question that you don't know the answer to. That's gone by the wayside for me. I ask a question. Hopefully I've thought about it hard enough where if I ask a question, whatever way they answer, one way or the other is going to help me. So I've got that, and then the other thing is,
I think that's true, that there
yeah.
can be those cases where you don't know the answer, but there's no good answer for them.
Right. And then I think too, like you said, you got to listen to your questions and answers, because if the answers aren't what you expected, but they're good, you got to go with that. And the other interesting thing, Monty, I've learned through the years, sometimes you have a really good point you want to make in cross, and they come up with a better answer than what you were trying to make. And a lot of young people say, "Well, I got to get to this other point that I had," which will hurt the answer they gave now in trial. Stay with the answer in trial, even if you don't get that answer you were trying to get to. In other words, take what they give you and don't necessarily try to get back to what you were trying to do. Um, so,
Yeah.
so I actually use both methods. I use a lot of depositions in cross exam. A lot of people don't. I do. I cross-examine, and if they differ significantly from the depo, I will read the depo. I use documents to impeach if they say something untrue. Um, and I'll try to tell my story by the way I frame the questions, which is what you're talking about. Spence does.
Yep.
Bugliosi did it too, Vincent Bugliosi. I ask in the no matter what the answer is, the question becomes important in the theme. So whatever my, like for example,
Right.
in my case, I just finished the plaintiff's case. They gave this guy a memo at the very last day when they fired him with all the things he'd done wrong. And I said, well, why did you kick a guy when he was down? That was my question. Didn't matter what they answered. My theme was you're kicking a guy for no reason when he was down. And I don't know what the guy said on his answer, but didn't matter. The question became, that's not evidence. We all know it's not
But
evidence,
that's the
but
theme.
that's the theme. So cross exam is, I think, where really great trial lawyers can rise to the level that you hopefully get to see in trial. Cross exam is the true art of doing trials.
I think that's right. Now let's talk about another aspect of cross, because we're talking about methodologies. But one of the things that I learned as a young lawyer, and you may have been smarter than me, but my mistake in the first few trials was I hated the witness. I was trying to destroy them. They were my enemy. But the jury gets pissed off at that. So you got
So
to learn to be nice and professional and very likable, even though while you're asking these questions and they look terrible.
100% agree with you. I mean, I could not agree with you more. One of my partners who never could change his style, he was vehement. When he stood up, his hair was on fire. He hated that witness. And to his credit, he won a lot of big cases because the jury knew when he stood up, it was going to be exciting because he was going to come at him full bore. I think it takes a much better lawyer
Yeah.
to attack and destroy someone in a really nice way and thank them at the end of the jury cross exam. I'll tell you, I one time eviscerated an expert with my father-in-law sitting in the audience. And came back thinking, oh, he's going to say that was great. What'd you think of my cross? And he said, you didn't thank him at the end. I said, what? He goes, you did
Ooh.
not thank him at the end. Um,
Ooh.
so he noticed that I now thank every witness. I say good morning or good afternoon to every witness, even if they're a terrible witness on the other side for me. I make sure that I thank them, and I make sure that I'm always polite to them. I make sure that I let them talk. If they talk too much, I'll cut them off, ask the judge to cut them off. Um, but you're exactly right. That's how I was when I first started. I'd be so, vehement about this witness, I'd stand up, my face would be beet red, and I'm gonna destroy this guy like on TV. And I think sometimes the jurors resented. One time I was on the rail, and the plaintiff was sitting right behind me, and I was blocking the plaintiff from seeing the witness. I don't think I did it on purpose, but the jury really was mad about that. They came out afterwards, even though I won, and said, "Hey, you were blocking that plaintiff." And I said, "Oh, I didn't mean to." "Yeah, you're standing right in front of him. He couldn't see." So they notice if you're impolite. They notice. My last trial, for example, big time law firm, guy from Yale, Harvard. Every time he'd use the podium, he wouldn't put it back. And we'd have a break, and they'd have to, walk by this podium. So every time he'd leave, I'd move the podium so that they could walk by. And I believe they noticed that. I mean, why would you not move it?
Oh, they totally notice that. I think
Yeah.
not only do you have to be pleasant in doing your cross and your direct, but the jury's watching everything. You have to be pleasant to the judge, to the court clerk, to the bailiff, to the court reporter. You got to be professional and courteous to everybody and to the jury. And I mean, my goal in trying cases was nobody's going to out nice me. And if at worst, it'll be a draw. But it's
Yeah.
amazing how often somebody on the other side does stuff like they don't put the lecture back or the podium back, right?
Yeah. Now I'll give you a quick example of a funny one. I'm testifying as an expert, and it was a guy from San Diego, whose name I'll leave out. When I finished, he walked up to me, shook my hand. Now he's the other side, cross-examining me as the expert for the defense. Congratulations, I just got trial lawyer of the year. Congratulations on getting trial lawyer of the year. Great result. And then he shakes my hand in front of the jury, and then I walk out. And I'm thinking, well, that's too nice. I mean, that went too far. You don't want to do that. You don't want to go that far. But I mean, that same lawyer, when he does closing, says, to the court, to the jury, to my esteemed colleague, he's a very, very polite, gentlemanly person. But yeah, always, I totally agree with you on that point.
Yeah, you really have to do that. So let's go into some of the things you got to deal with in final argument. So in your cases, you're probably dealing with catastrophic injuries and big damages and all that kind of stuff. And the plaintiff's attorneys are going to be putting huge numbers on the board and all that. And as we all know, the jury is not given any particular way to figure out something like non-economic damages. At least with economic, they've got numbers and they can calculate and deal with stuff. But non-economic, how do you help educate the jury and give them stories or analogies to help them figure out what a reasonable number is in non-economic damages?
So I try to tie it to what they make in a year. If they don't make a heck of a lot of money, I'll try to say, this is more money than they would have ever made in their entire lifetime. The plaintiff attorneys have a lot of clever ways of, I mean, I've been up against every plaintiff's lawyer that's a good one in the state, probably. I mean, they have the case where there's a fire in the museum, and
Yeah.
the guy's told to go back in and grab the Picasso. It's worth $30 million. And instead he comes out with a lady on his shoulders. "I told you to grab the Picasso." "Yes, but her life is worth far more than that Picasso." Or they go day by day. "This is just, we're asking you for this amount per day, per month, per year." And that adds up to whatever. Or they go with future distress. "You've seen what has happened already. This is what's going to happen in the future." And right now he doesn't have his family with him because he just isn't the same person. And so I try to counter that with, let's be realistic. This is more than the whole budget for the state of California, or this is just not a realistic number that anybody can accept. I try to tie it to reality, rather than let them kind of give these analogies and not give something that counters it.
Okay. In terms of your final argument, what is your strategy in your final argument, and what are you trying to do to help the jury make that decision?
So I always believe you've got to give a number. I don't think you can leave them with no number from the defense. So I will counter with, even in a defense verdict situation, "Look, I don't think this is a case where you should find liability, but if you do, this is the number, and I think here's why." and then I try to tie it to solid examples. The doctor said after 6 months he was fine, or he was able to go back to work, and he worked for 3 years. Now he's saying he's totally disabled, but he was able to work those 3 years, so something must have happened afterwards. I try to tie it to solid examples. One, two, I think in closing, I try to let the jury know this is not an emotional situation. You got to be more pragmatic. You got to be more, have your feet on the ground when you look at all this. Don't let emotions run away with you. And three, if your client's really bad, again, a drunk driver in a car accident case, or you try to hammer on somebody else, you hammer on your expert being great, or hammer on their expert not being great, or focus somewhere else other than your client. So that tends to work. Or yourself, try to make yourself the person that they're going to have to reward against. Somebody's going to have to make an award against you personally, and it's that seems to work for me most of the time.
Well, we've talked about this in different ways without naming it, but credibility is part of what you're dealing with there, because if they like you, if you've got credibility, that's going to help you in your case. And if you built that credibility, that's going to make a difference. So that's an important part of trial too. Credibility for the lawyer, for the client, for the case, for the story you're telling. Is that your experience?
Absolutely. And I think here's another interesting point as a side corollary to that. I don't think it's ever good to attack the other attorney. I don't
Yeah.
think, I've had lawyers attack me. They especially attack my partner Zurek for some reason. But I don't think that's ever good. And I think hopefully you haven't said anything in trial that's untrue or incorrect, and that you maintained credibility. A lot of lawyers go back and say, well, here's what they said in opening, and they didn't do this, and this. I don't know. I don't think a jury is that tough on you that they think you've got to maintain everything you said in opening. Because sometimes stuff happens that I'm going to call 4 experts and you only call 2. And I
Right.
always explain we didn't need the other 2. It was the first 2 were so good I didn't need the second 2. But I think credibility is most important, and I hammer on that on Casey instructions. I just go through that witness. One witness, like this case we just finished, was one witness is as good as multiple witnesses if you believe them, and if there's
Right.
and I point out why maybe you won't believe or can't believe some of the witnesses put up by the other side because they did this or that or whatever. And in the case I had, they were actually looking to the defense attorney for instruction. He would signal them. So I said, I don't know if you caught this, but they would look towards the defense attorney, and you can, say to yourself, well, why were they doing that? Why not just tell us what really happened?
Yep. Now, you probably go through some of the verdict form with them in your final argument, don't you?
I go through every single time. I go through each and every part of that verdict form,
Yeah.
and I tell them how I want them to answer. Now, in the
Every
last
question.
every question. The
Yep.
last, what happened in the last trial, this judge was great. He just would roll no matter what. We didn't have a verdict form finalized. So I said, well, this is not the real verdict form you're going to get, but this is generally what you're going to see.
Oh,
Here's how I
that's
want you.
good.
Yeah. So I said, generally, here's how I want you to answer it. Check, check, check. And when you get to the end, fill this in. But yeah, I absolutely, especially on the defense side, go through special verdict form because they've got to answer yes to multiple subparts. And if they
Yep.
don't, you get a defense verdict. So
Right.
yeah, absolutely go through that verdict form, point it out to the jury. Here's what it's going to look like if you already have it. Here's what we want you to answer from our side. If you're with us, this is how we want you to answer it.
Well, Chris, this has been a great discussion, and you share a lot of great information that'll help all kinds of lawyers. And I think what's great about this podcast is I think it helps people who haven't tried any cases, but it helps people who've tried lots of cases. Helps everybody because you can get new ideas from other people. So to close this off, I'd like you to share if there's somebody who's a younger lawyer or hasn't tried many cases and they're interested in becoming a trial lawyer, what advice would you give to them to try to learn how to be a great trial lawyer?
Well, I would tell you, Monty, I still love what I do after 40 years. I love being in trial. I'll be in trial many times this year. What we do as trial lawyers It's no accident that they make movies about it and they write books about it because it's exciting, it's interesting,
Yep.
it's something the public loves. I will go back to what I said earlier: preparation, preparation, preparation. You can't prepare enough. The more you prepare, the more you know, the more you think about your case, the better your trial is going to be. So that you don't want to embarrass your client, you don't want to embarrass yourself in front of that jury, and you
Yep.
want the judge to know that you know the trial and you know the case and that you know what's going on. So preparation, 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 and it's, to me, there's no better profession than being a lawyer, and especially a trial lawyer.
Yeah. Preparation is key. I've always thought that I want to be properly prepared because I know I may not be the smartest one in the room, but my goal is that nobody's out prepared me.
Yeah,
I'm sure that's your goal. Nobody's out prepared you.
exactly. Absolutely.
Well, thanks for the good advice. Thanks for being a guest today. Really appreciate the time. Thank you, Chris.
Thank you so much, Monty, for having me.